Kurt M. Chambless et al. Versus Terry L. Rutledge et al.
Other appellant? Afternoon. No problem.
May it please the court, my name is Steve Jakeway. I'm a member of the Chattanooga Bar. I am here on behalf of the plaintiff appellants, in this case, Kurt and Jill Chambless. This is a case where—
Mr. Jakeway, have you reserved your time?
I previously asked the clerk to reserve 2 minutes for this.
Good.
I'm a little bit out of practice. I apologize, Your Honor.
Don't worry about that.
This is a case where we are asking the court to set aside a motion, an order granting a motion to dismiss that was entered by the trial court with regard to the 3 defendant/appellees in this case, relating to our clients, relating to the declaratory judgment action as to the enforceability of a restrictive covenant, an amended restrictive covenant. The facts are, very briefly, let me state, the parties to this are all property owners and own houses in a subdivision in Chattanooga known as River Glen subdivision. It is a very, there are just 4 houses. It's on the Tennessee River. Houses probably worth in excess of several $1 million apiece on large parcels of property. My clients, the Chamblesses, bought their lot back in 1991, the same time the Rutledges bought. My clients immediately built their house. It's been built for approximately 30 plus years. The Rutledges waited approximately 10 years before they built their house. The other property owners in there are the Doties and the Maxwells. When the subdivision was developed, there was a series of restrictive covenants that were in place. The restrictive covenants required, amongst other things, that if any party or property owner built a retaining wall, it had to be faced with either stone or brick. It also had a requirement that you could not remove a large portion of trees anywhere in the neighborhood at any time unless it was necessary to build a house or to build a driveway. The circumstances are this. Several years ago, the Rutledges, who are neighbors to my client, the Chamblesses, built a very large retaining wall, approximately probably 60 feet, probably at its highest part, probably 10 feet, a massive retaining wall in between their lots by the driveways. And when they built that, they did not put any type of facing on it. It was just plain concrete. And also, when they built that, they moved a large parcel of trees that served as a barrier between the driveways. My clients, the Chamblesses, asked them repeatedly what facing they were going to put on the concrete retaining wall to bring it in compliance. They put them off for a period of a year or more while they constructed it. And then when the time came where they had to do something, they decided that they were not going to put a facing, but they would go to the other neighbors and get the restrictive covenants amended to take away those requirements, which is in fact what they did. The restrictive covenants had, one of its requirements was that if they were amended, it had to have a vote of 66 2/3 majority of the neighborhood. What happened in this case is there were discussions about that, about amending it. The Rutledges proposed a procedure to follow that they set out in an email to allow the amendments to be considered. They, in fact, did not follow their own instructions with regard to the amendment. My clients filed a breach of contract action initially against the Rutledges for their failure to comply with the original restrictive covenants. That is before they were amended. The court, the Rutledges filed a motion to dismiss on that action. The trial court correctly said that even if the amended restrictive covenants had taken place, which shortly they did, that you could not retroactively correct that violation of the initial restrictive covenant, but and denied that motion to dismiss. Then several months passed, and then all of the parties filed a motion to dismiss with regard to we amended the complaint to ask for a declaratory judgment as to the enforceability of the amended restrictive covenants. We also asked for other causes of action, breach of contract, et cetera. But as to the declaratory judgment action, they filed a motion to dismiss all three of them with regards to that. They in fact said their argument was, well, the plurality clause of the original restrictive covenants had been met because 3 out of the 4 had approved it, and that it had been properly filed, and therefore they were entitled to that. We filed objections and responses pointing out that the amended restrictive covenants were done in an arbitrary and capricious manner, which I think Tennessee courts have uniformly said that is in fact that can set aside a otherwise valid restrictive covenant.
Mr. Jakeway, let me interrupt you for a minute just to make sure I understand in my mind. Is there anything still pending with regard to the facade of the retaining wall?
There is.
Okay, but it's not a part of this appeal. We're just deciding whether or not the covenants were arbitrarily or capriciously enacted.
The original violation of the initial restrictive covenant by the Rutledges, that's the one that the court denied the motion to dismiss. That is still pending before the court. When we argued that they were arbitrary and capricious, and the judge granted their motion, and in the order that they entered, the court basically said, and I guess the court speaks through its orders, found that they had in fact met the plurality clause of the restrictive covenants, that it had been properly filed with the registrar's office for Hamilton County. And I'll read here. Then it says, accordingly, the court finds the plaintiff's amended complaint lacks sufficient allegations to articulate a claim for a judgment declaring that the new covenants are arbitrary, capricious, and invalid. The court did not do any type of specific analysis with regard to the allegations that we had in our approximately about 70 paragraph complaint. And in it, we alleged 6 or 7 different instances where there had been a showing of bad faith and arbitrary and capricious nature, and because of that, that we felt like that they were that the declaratory judgment should be allowed to move forward and to proceed in that manner. But the court entered that order and then certified it for purposes pursuant to Rule 54, pursuant to that rule for purposes of this appeal, and that's what we're here today. As far as factually, what happened is the reasons that we alleged that it was arbitrary and capricious, when in fact there were several things that happened. First, when they did amend it, they set forth that none of the exterior of any of the 4 houses could be constructed of stucco. Well, our client, the Chamblesses, were the only party that had a stucco exterior. They had had it for 30 years, but yet they said that that would be a non-conforming use with regard to the restrictive covenants.
But that didn't really affect your clients because they're grandfathered, right?
Well, yes and no. They did point out, because there is language that says, however, if there is a non-conforming use and the house has to be reconstructed, that they could still go back to the original stucco. The problem is, and we alleged in the complaint that a real estate agent, prominent real estate agent, had stated that because we were the only non-conforming use in there, that would adversely affect not only the value of our house, but the value of the neighborhood itself. To have that, you're talking about a $2 or $3 million house, and the one. Is
that testimony in the record?
There was a statement that it was allegation. We never got.
I'm just wondering how it would adversely affect.
Well, I mean, I can tell you what the real estate agent said, but that's not in the record.
Okay.
But the allegation is, and for purposes of a motion to dismiss, I think it's important two factors. One is that on a motion to dismiss, you have to assume that all of the allegations in the complaint are true. And secondly, with regard to a declaratory judgment, the law in Tennessee is pretty clear that it's very rare to grant a motion to dismiss as related to a declaratory judgment because they are basically to decide an ongoing dispute, and there is absolutely a valid ongoing dispute in this case. But nonetheless, what they did was they did that about the exterior, and then they also, one of the things they did, but they later corrected it, was they were going to say that that any boathouse that was in the neighborhood had to have the same exterior as the house. Well, the only people that had a boathouse in the neighborhood was my clients. They subsequently pulled that out, but I think that's important to show the bad faith that they had.
Excuse me for interrupting, counsel. Was that with regard to the initial restrictive covenants or the amended ones concerning the boathouse?
That was with regard to the amended restrictive covenants. Now, it did not end up in the amended restrictive covenants. It was one of the proposals that they had discussed, but it did not end up in that. What they did do also, of course, is pull out the requirement about facing on any type of retaining wall. They also pulled out the requirement about not removing a large set of trees. They did those as well. We had the allegations in our complaint also refer to emails between the parties where there were statements made that were misleading as to the nature and reason for us. The whole reason, our clients just wanted them to comply with the restrictive covenants. And it's clear, and we allege in there, which I think have to be considered truthful, that those emails and the whole actions on behalf of the Rutledges to go around this and representations made in order to get that vote were arbitrary and capricious and in bad faith, and therefore, at a minimum, we should be allowed to move forward with our case. We had not done very little discovery. We'd done some written discovery, but no depositions have been taken. But it's not a situation, we just have to show that there is a possibility, once you consider the allegations in the complaint, that we might be successful with regards to the declaratory judgment. It's not a persuasive requirement in that situation. But we've alleged in the complaint, in our brief, the instances where it was showing that it was arbitrary and capricious and bad faith, and therefore that they should be, the motion to dismiss, the order granting it should be set aside. I now save 1 minute. Thank you.
Thank you, sir. How many arguments will there be presented as far as the appellee is concerned? 2 arguments?
There are 2 of us here to argue it in the sense that I'm going to take the first 10 minutes.
Okay.
And Mr. Barham's going to take the next 5 minutes, if that's okay with the court.
Sure.
So one clarification, there were 3 motions to dismiss after the amended complaint. So we back up. My clients, the Rutledges, were the only defendants when the initial complaint was filed. We filed a motion to dismiss with regard to that complaint. There was an amendment done of the old covenants, I will refer to them, whereby the new covenants, that is the restrictive covenants, were adopted by 3 of the 4 landowners. I'm going to digress and tell you it's a 2-step process. And there's nothing in the amended covenants that provide for, quote, a procedure. The procedure is takes a vote, or the vote is done by signature on the amended and restated covenants. It takes 66 2/3. There's 3 out of 4 that signed it, 75%. And it's the filing of that with the Register of Deeds. That's the only 2 items that are necessary to be done.
Excuse me for interrupting, counsel. How was the process or the procedure established or crafted if it was not in the original
There was no procedure established in the sense that Mr. Rutledge offered to take comments and try to compile those. There's nothing in the amended covenants that provide for that, and there's nothing in the original covenants. He did that as a courtesy, but that's not a required procedure. And again, with regard to this, I mean, everybody had input, everybody had time. They actually, that is, the Chambless hired an attorney, Ms. Hill, in Mr. Jakeway's office, who provided comments to the Rutledges and to the Dowdys and the Maxwells. And they had hired one attorney to do it all, which was Mr. Stoltz, Arnold Stoltz, in connection with that amended and restated covenants. But to suggest that there was some kind of procedure within the covenants, the restrictive covenant document itself, there is not. There was oral discussion, there were emails and discussions, and they exchanged documents and they exchanged comments, but there were no discussions. There was a deadline somewhat established for people to either sign or not sign whatever the document was. And there was a period of like 3 months with regard to that. So when it's from the start to the finish. And so again, for that purpose, to suggest there was some type of procedure that everybody agreed to is not correct. In fact, what happened was Mr. Chambless himself stated that he did not agree to that process, and that's in an email in the record that he sent to the Dowdys and the Maxwells, saying that they did not have to adhere to Rutledge's procedure. And it was he that was complaining with regard to that. And so, again, I'm fairly adamant about that, but there was no, quote, prescribed procedure with regard to the amended and restated restrictive covenants. It just took two things, a vote and by signature and a recordation with the Register of Deeds in Hamilton County. What's interesting, we have a number of conclusory allegations contained within the amended complaint. I do want to go immediately to this comment of counsel as to what a realtor might opine. I mean, again, when you say you're going to assume all allegations are in favor of the proponent of that allegation, they have to be allegations of fact. Opinions are not allegations of fact. Some realtor's opinion as to what might harm a particular project is an opinion. It is not a fact. There is no credence to be given to such opinion until, I mean, again, for the purposes of the motion to dismiss, you are supposed to assume and give inferences to facts with regard to those. But to suggest that you can put in a statement from a third-party realtor that is somehow a fact is just incorrect. It is an opinion. So the four reasons they say that this should not be upheld is because, one, it failed to serve a useful purpose. Two, they were based on a mistake of fact. Three, they were based on material representations made by the Rutledges. And four, they were adopted in bad faith with an attempt to harm the Chamblesses. I've already spoken to the realtor. That was one of those things. That's what they relied upon for that serve a useful purpose in connection with their amended complaint. There are no other allegations supporting the conclusion that the new covenants failed to serve a useful purpose. Interestingly, I will submit to you, there is nothing in their brief that even references failure to serve a useful purpose. They didn't mention it at all. Secondly, mistake of fact. They assert that the Chambless home is furnished with synthetic stucco, and they allege that the Rutledges, my clients, mistakenly believed their home was finished with non-synthetic stucco, all of which is irrelevant. As Justice Davis has already pointed out, the amended and restated covenants say whoever has any non-conforming use that's presently in existence with regard to any reason in this provisions of this restricted, amended, and restated covenants are grandfathered. If their house is destroyed or fire destroys it, they can rebuild it with the same non-conforming use. There is no adverse impact to the Chamblesses with regard to it. There is no mistake of fact that's relevant to this decision-making in connection with this matter because of, just look at the amended and restated covenants because it provides for that. Then they say misrepresentations. They, again, state in their complaint that the new covenants misrepresented the exterior finish of the Chambless' home and the existence of a multifamily dwelling on the Chambless' property. Well, the old covenants, as well as the new covenants, have always barred multifamily use. To suggest somehow that's going to encourage you to adopt it in the new covenant, that makes no sense because it was in the original covenants to begin with. You have no multifamily use. We'll have to get into the argument whether that's true or not true. It's just not relevant with regard to this. And there is no misrepresentation made in connection with that. And the static ban, again, does not apply. That's the second misrepresentation that they allege in their amended complaint. So they also claim that there were some misrepresentations about Miss Chambless. And again, they allege that someone called her the neighborhood police. Okay, that may, again, I don't know that that's a fact. I would say that that's a subjective opinion, hopefully not an objective opinion, but it's a subjective opinion with regard to what everybody's statement is, but that's not an allegation of fact. So, again, then it's malice, bad faith, and or intent to harm. We have a draft of a set of restrictive covenants that were never adopted. They might have been reviewed, but never adopted. But somehow that's a bad faith to even suggest something about a boathouse with regard to this particular property. It's not there. It's not put in existence. But to say you got a separate document that's in, nobody signed it, nobody's done anything with it. But to say that that's that's bad faith. In fact, what happens is in the amended covenants and restrictions, everybody recognizes that the TVA, not the neighborhood covenants, regulates boathouses. We can't even regulate boathouses. TVA does that because it's on the river, and they're the ones who take charge of that. And that's what's referenced in the amended and restated regulations. Now, there are, in fairness, new allegations in the brief that are not in the amended complaint. And I would submit to you, those are not really before the court in a proper manner. And I'm out of time.
Thank you very much, Mr. Chamberlain. Yes, sir.
May it please the court, Steve Barham from Chambless Bar and Stoffel, Chattanooga Bar, here for the Maxwells and also speaking on behalf of Scott Shaw for the Doties. Primarily to address the second issue on the appeal, but I wanted, before I move to that, to address one thing very quickly, and that's to point out to the court that both the Hughes versus New Life Development Corp. On page 479 of the Tennessee Supreme Court opinion and in the FSD Corporation Court of Appeals decision that we've cited extensively in our brief, make it very clear that when the court is evaluating an issue exactly like the one before it, that what's important is the restrictive covenants themselves. And what the court is supposed to do is say, is there evidence that these restrictive covenants are arbitrary and capricious. Not that the process and that the neighbors were mad at each other. Because can we imagine how many times if it's, well, the neighbors were all mad at each other, and so we ended up with adjusted covenants. I mean, the FDS Corporation is perfect, right? Because it's, the neighborhood said, we don't want temporary, short-term leases in our neighborhood, so we changed the rules, and you can't do that anymore. And they litigated that. Well, they were not best friends when that happened. I can guarantee the court that that's the case. And so the issue is, are the restricted covenants, the new restricted covenants, are they arbitrary and capricious? When you read the plaintiff's brief, you look at our responses, it's clear that there's really nothing in those amended, restated covenants that are arbitrary, capricious, or in any way harm the Chamblesses. And that's why they're stuck arguing with, well, they were mad at us and they said mean things and they did these things and they weren't good neighbors, and so the court should let us move forward and say they were acting in a mean way towards us because we just simply wanted a facade on their big ugly retaining wall. Well, that's not the standard as set out in the cases as we highlight in our brief. Moving to the second issue on the appeal, which is our clients, the Maxwells and Doties, were completely dismissed with the court's order. And there were two issues on that. One dealt with the court finding that there was no issue with the amended restated. They were properly done and properly recorded, and so they are the covenants that apply to the property. And the other dealt with some remaining questions that the court can find in the amended complaint, paragraph 62, subpart F and subpart G, and paragraph 63, subpart E and subpart F. Now, though these are parts of the declaratory judgment that remain, but the court, the trial court found they do not apply to the Maxwells or the Doties under TCA section 2914-107, which says, when declaratory relief is sought, all persons shall be made parties who have a claim or an interest which would be affected by the declaration. Well, when we read 62F, it asks whether the actions of Rutledge in hiring an attorney and paying an attorney without authority of Chambless was improper. 62G, whether Chambless is responsible for payment of such attorney's fees incurred by Rutledge and the associates, and if not, whether Chambless should be reimbursed for the payment of such attorney's fees. And then we look at 63E, that Terry Rutledge did not have authority on behalf of Chambless to hire an attorney and pay the attorney with association funds, including funds of Chambless. And 63F, that Chambless be reimbursed for the portion of the special assessments they paid, which were utilized by Terry Rutledge to pay an attorney. The court properly found that when you evaluate the fundamental 107 question, does this impact the Maxwells or the Doties? The answer is no. The Maxwells and Doties voluntarily paid the money. They felt it was the right thing to do. They are not seeking the return of these funds. The question of whether Mr. Rutledge owes Mr. Chambless these funds, it's the old covenants that would apply to that, so it doesn't even affect the current covenants that apply to our clients' properties. They just have no role and no issue in that. And in fact, the plaintiffs admit in their brief that courts have discretion in determining who should be made parties to proceedings for a declaratory judgment. The trial court made that decision and said, I don't need the Maxwells or Doties for that. In addition, Your Honor, we believe that from the Maxwell and Doties perspective, that this case is one where they should be entitled to fees under TCA section 27-1-122 as explained in our brief. Thank you.
Thank you, sir. Yes, sir.
Thanks. Thank you. I would address several points. First off, the case law that Mr. Convalinka cited, the FSD case, the Supreme Court recently, that case was appealed to the Supreme Court, and within the last month, they recently ruled on it. The facts of that case, very briefly, were a situation where a party had had short-term rentals, some additional restrictive covenants were put in saying they could no longer do that, and he filed a lawsuit, one of the things he said it was arbitrary and capricious. Supreme Court says, yes, arbitrary and capricious absolutely could be a reason. Unfortunately, the only reason that the plaintiff cited to suggest it was arbitrary and capricious was because it was retroactive. And they said that just didn't apply in this case. It was not retroactive. But the FSD case, both in the Court of Appeals and the Supreme Court, reaffirmed what we're saying about arbitrary and capricious. I would say briefly, too, that we believe, if you read the complaint, that there are substantial allegations to reach the standard when considering a motion to dismiss, and that is, of course, that those allegations are in fact true, and we've set those out. I will not review those. I will address briefly the circumstance regarding the second portion of the appeal, and something that Mr. Convalinka said was that they hired one attorney to do it all. No, that's not what occurred. What happened is there was money that the parties would contribute to the neighborhood, and one party would keep up with it, and it would do maintenance, things of that nature. Well, they said, hey, we need a special assessment to pay for this attorney. And in this case, under the restrictive covenants, my clients paid it under protest and said, we don't agree with this. And then, in fact, went out and got their own attorney, but they did take the money. The other three parties, Mr. Rutledge was the one that was assigned for that year taking care of the money. And in fact, that same attorney is who's representing them with regards to this lawsuit. So we think there was absolutely a problem and a conflict with regard to that. And the law is pretty clear with regard to a declaratory judgment that when there's an actual controversy about an issue, it requires a declaration from a court. The plaintiffs must name all persons that have any interest which would be affected by the declaration. Well, the money was paid by the neighborhood into a separate account that was used to pay for the attorney. And we allege that that was, in fact, a justiciable issue. I don't think anybody disputes it, and that absolutely would need decided as part of the declaratory judgment. That's the second part of our appeal.
Thank you, sir. I want to thank all the parties, attorneys, for their presentation. You should receive our opinion and judgment on this case within a reasonable period of time. You may be excused. Thank you very much. Mr. Campbell.